distinguished colleagues at the head table. Now the microphone is on. Shalimar spoke without a mic, but the excitement kept the voice to that level. Distinguished Honorable Chief Justice, learned magistrates, learned senior magistrate performing the functions of Chief Magistrate, Permanent Secretary of the Ministry of Legal Affairs, the leadership of the Guyana Police Force representing the Commissioner of Police, legal advisors and lawyers attached to the Guyana Revenue Authority, members of the press, special invitees. Once again, it's a privilege for me to be afforded an opportunity to speak with you at a very simple ceremony, but one of some significance. I want to begin by recognizing that this bench book is a product of the Juris project funded by the Government of Canada and executed by the Caribbean Court of Justice in collaboration with the University of the West Indies Cayville campus. They are the producers of this work, and for that they must get full credit, and I want to thank them profusely for sharing this work with the judiciary of Guyana, the Ministry of Legal Affairs and Attorney General Chambers, and most importantly, allowing us to replicate copies that we are here to distribute. The book was first sent to me to to keep copies for myself, for the Office of the Attorney General, and to hand over copies to the Judiciary and the Director of Public Prosecutions. Upon receipt of the book, I immediately went through the content, and I realized the amount of work that was done, the amount of research that would have been conducted, and the various comparative analysis that was done across the region, as it is a book written for the entire region. So you have the jurisdictions stretching from Bahamas in the north to Trinidad and Tobago in the south, the entire Caribbean, the relevant legislation analyzed and examined and explained, supported with or supported by case law authorities interpreting the very provisions that being analyzed and set out at the relevant places, so that a reader not only finds what the statement of the law is or the principle of the law, but he finds the statutory provision of each country and decided cases interpreting that statutory provision and applying that principle to a particular factual matrix. So the book presents a complete, and I dare say an authoritative manual that can easily provide the type of guidance that is required both in court and when more in-depth research is required outside of court. And only a few copies of the book came. And I thought that such a book with this level of effort being injected into it, with only a few copies available for distribution, would not only be a travesty for the administration of justice in Guyana, but a travesty of the efforts expended in the preparation of the books. And it is from that perspective that I ask permission to make copies for wider distribution. It is my view that if the prosecutors, the magistrates, and the defense counsel are singing from the same proverbial hymn book, how can you get the song wrong? And one of the greatest characteristics of a proper justice system is one that applies the law consistently and uniformly. How better way to achieve these two principal and crucial objectives when you have a singular manual from which everyone is seeking guidance. It will bring coincidence of the mind and understanding at a far greater rate than if the prosecutor is reading from one book, the defense is reading from another book, and worse yet, the magistrate reading from a third book. You will have a discord in the arguments, and great time and effort will have to now be expended in finding commonality in the three sources from which the law is being drawn in a singular case. That clash is removed and replaced by a common symphony with the utilization of a common source of guidance. And that is what the book presents. And that is the reason why the book is going to be distributed to the Director of Public Prosecutions Chambers, the magistracy, the judiciary, upper judiciary, the police prosecutor's office, the special prosecutors that we have recently trained, and as far as possible across every divisional command, what do you call it? The regional division of the police force. I don't know how many copies, we may have to do more. I heard the DPP call for one in every police station. I don't know if I can accomplish that feat. But what I know is that one will be in every divisional police division across the country. Major Crimes Unit, of course, will have. The Police Legal Advisor will have. SOCU is here. They will have, because they do prosecutions. The Guyana Revenue Authority, they do prosecutions. They will have copies. And the Anti-Narcotics Unit, CANU, Customs Anti-Narcotics Unit, they will have copies as well. And these are the major prosecutorial poles in the state sector. So all of them will have sufficient numbers so to which they can make reference. The book, as I said, is a complete code. It begins with the arrest of the defendant or accused person, and it takes you through every step of the criminal process, all the way to conviction. And every legal link along that chain, it situates a chapter. So arrest, there is a chapter. Service of summons and the initiation of the complaint, there is a chapter. The initiation of the proceedings. Then entering of plea, bail, and then the other procedural issues, admissibility of confession statement, types of admission of evidence, types of exclusion, the exclusionary rules of evidence, the trial process, conviction, functus officio of magistrate, sentencing, reasons for decisions, and it even goes on to deal with specific legislation for which there are regular prosecutions. For example, the Customs Act. For the people from the GRA who are here, there is a chapter dealing with the Customs Act, and there is a chapter dealing with road traffic offenses. There's a chapter dealing with abuse of process. There's a chapter dealing with committal proceedings. The DPP spoke about the good year hearing and sentencing options and sentencing methodology. All of that are laid out chapter after chapter in the manner in which a criminal trial would ordinarily unfold, or a criminal prosecution or a criminal case will unfold. The chapters list the process in the chronology in which they will unfold in the court. So it's very easy to follow. When you compare it to what is taught in the law schools of the Caribbean, it closely resembles a compilation of the 2-year syllabus in respect of criminal practice and procedure, the course, and some degree of the law of evidence. So this book, I believe, will provide tremendous assistance in understanding and applying the law, and obviously will bring resultant badly needed speed in the criminal justice system. And it complements the support for criminal justice project that is being financed by the IADB and executed by the Ministry of Legal Affairs. And hence, I was able to use finances from that project to fund the replication of these books for distribution. And as I have reached the project itself, permit me to remind of the important initiatives that we have completed so far in the project. The project has various elements or various components geared towards achieving the important objectives of reducing prison population, reducing pretrial detention, and bringing greater speed to the criminal justice system. From the legislative front, we have already completed a Bail Act, and that is already undergoing review. The Chief Justice has kindly pointed out to us some procedural hiccups, and we are in the process of correcting them. And once they are corrected, we should have a very functional and modern Bail Act. I have spoken at length about the abolition of preliminary inquiries and the paper committal legislation that is already in the Parliament. I have spoken about the plea bargaining legislation that is already in the Parliament, and all these legislation are intended to bring greater speed to the administration of criminal justice and to reduce the prison population. A preliminary inquiry takes an average of about 3 years. When this paper committal bill comes into force, it can be done within 3 to 6 months, once the prosecutor and the defense discharge their respective burdens and the magistrate acts expeditiously. We are working on a new Evidence Act that will bring our 1893 evidence law to a place where it should be. We have already completed we are working on a rehabilitation of offenders bill, a new one. We have one, but it's now 40 years old. We are working on sentencing guidelines with the judiciary. The DPP spoke about the need for sentencing guidelines. We are working on, I spoke about the Rehabilitation of Offenders Act. I made some notes here that I have some difficulty in reading. We are working with the police to review and modernize the police standing orders. Chief Justice has regularly admonished lawyers appearing for the police in civil proceedings about the conduct of the police as established by evidence to her satisfaction as a court. And I, being your lawyer in those courts, and my representatives, we bear the brunt of those admonitions. As a result, we are working, Madam Chief Justice, with the police and the University of Guyana to review the police standing orders, to inject into it greater accountability, greater responsibility, and to bring it in sync with the new realities of policing and the new developments that are taking place in relation to the rights and freedoms of the individual. So you will have a different regulatory framework even at the level of the police standing orders. We have unfolded a special prosecutors program. All of that is funded under this project, by which we have trained, or we would have completed training, over 40 holders of Bachelor of Laws degree and put them under a special training program at the University of Guyana, and they are now part of the police prosecutors in the various magistrates court in regions 4, 3, 5, 6, and 10. We have a smaller number under training for this year, and they will be added to the complement. We have equipped a separate building where those special prosecutors are being accommodated. We have built an office and residential facility for the Director of Public Prosecutions on the Niming on the Essequibo coast. And Friday we will be opening a new facility called a Hope and Justice Center on the east coast of Demerara in collaboration with the Ministry of Human Services. This is another unique initiative which will bring under one roof health services, social probation services, legal services, medical services, and accommodation for victims of domestic violence, sexual abuse, trafficking in person, and or violence committed against our children. So you have a one-stop center where a number of services can be provided to the victims of the type of abuse and abuses that I have mentioned. Many a times, these people can't go back. They don't have nowhere else to go other than go back to the place where the abuse is emanating from. And that most of the instances, when examined, establish that the abuse intensifies when the victim returns. In particular, if the victim raises an alarm, or worse yet, decides to go to the police station. The victim not having another alternative is forced to return to the abuser. Now there is a facility to which that victim can go and remain there, at least until alternative arrangements can be made. We are doing one in Region 3 as well, and it is hoped that we can put one in different population centers across our country. This simple initiative will save lives and will bring a place of reprieve for victims of these atrocities. This project is funding that initiative as well. You must be aware that we are working on a new prison system, modern prison system. Our prison legislation, for example, is a 1955 legislation. The prison is regulated with that framework. The objectives of punishment were different in 1955 than they are now. Then the concentration was more on punitive measures. Now the concentration is more on rehabilitative measures. So you have to restructure and refashion a whole modern edifice and administrative structure that must require a new regulatory framework to support it. This project is financing that statutory regulatory framework, and that initiative is ongoing. We have already done a tremendous amount of work under this project within the prison service itself. We have established a computer center within the Guyana Prison Service, and we have furnished that center with hardware, computers and printers, and we have trained people to train prisoners in the use of those technological apparatus. We have about 60 prison officers who are going to be enrolled at the University of Guyana for this coming academic year to be trained in different areas relating to their duties as prison administrators and officers. We have worked with the Guyana Police Force in many, many endeavors. We have supplied them, and we continue to supply them with all the computer hardware and other support services that they need to ensure that we stop using handwritten statements in criminal proceedings. You ought not to get a handwritten statement in a criminal trial anymore. And magistrates must take objections, because I invited them to supply me with all the computers and printers necessary, and also a list of the other supporting services that they need to get it done, in terms of typists, etc. They did. Still, I got a report that they're using handwritten statements in some cases. I wrote them again, and they gave me another list of computers, which we are now publicly procuring, which they said will address all their needs. And I'm saying this on television, so I hope somebody tell back the police commissioner and the administrators in the force. This is 2024, sorry. And when we speak about transformation and transforming this country, we are not speaking the words only. We are walking the walk and talking the talk. So in this transformation, we can't have handwritten statements anymore. We have passed that stage. We are rebuilding all the police stations now into modern edifices. We are working now with the magistracy in terms of the clerk, the magistrate court clerk, and the accounting system there, both in the High Court and in the Magistrate Court, to implement and execute the e-ticketing exercise for road traffic offenses. Right now I'm working on the preparation of a document to execute the project, because the cameras are all over. I believe the legislative changes are being concluded, so we now have to roll out the project. So we are transforming this system in every aspect. You would have heard the Chancellor speak about e-filing and moving towards paperless litigation. The government is providing the resources for that to be done in the judiciary. And we are also within the government sector itself and other state sectors building similar capabilities. The judiciary doesn't operate in isolation. So we want, in the government system, we are working towards transitioning all government processes into e-transactions. And that's why we passed an electronic transaction bill. It's now law. where in the government sector, everything that is being done manually will be done electronically as we start to build the capabilities going out. But the law is already there. The technical people now got to build out the different platforms. The foundation is there. They now have to build the edifice. In this very project, we are building a management information system which will collaborate with the system that the judiciary is building, because we are part of the legal sector. And we are tying it up with agencies that perform important adjunct services to the legal sector. So the probation department, the Guyana Prison Service, the Guyana Police Force are all integral linkages. They are building out their individual capabilities, and then hopefully the qualified technical people will make the strategic linkages of these different platforms so that we can have this collaboration and flow of functional responsibilities in an integrated system. And that's the type of vision that we are working to execute. So, back to the book. I have migrated far away from this book. But this book, as I said, is a very timely addition to the repertoire of work that we have done and we continue to do in the various areas connected to the administration of justice. We believe at the level of the government that the administration of justice, the rule of law, and constitutionality are pivotal pillars upon which our society rests. None of the developments that we are working so hard to advance, none of the social realities we are trying to create can be realized unless we have the rule of law, unless we have an efficient, independent judicial system for settling our citizens' disputes, and unless we have constitutionality in the country. None of these things are possible. And that is why we continue to pay so much emphasis and provide so much resources to ensure that the rule of law prevails and that our system of justice remains unpolluted, competent, and diligent. So, this book is important, and I hope that the best use is made of it and it is utilized in a manner that will add another impetus to the objectives to which I have alluded to in my presentation. Thank you very much.